So far as appeals are concerned, you're either talking about appeals against conviction or appeals against sentence, sometimes both. So far as conviction appeals are concerned, the Court of Appeal will quash a conviction if they regard it as unsafe. That's the test. Was the conviction in the Crown Court safe or not? Generally speaking, this is a matter of law that depends on things such as whether the judge has summed the case up properly, whether he's made rulings of law during the course of the trial that are unfair, whether he's allowed evidence to be given that shouldn't have been given, things of that sort. Sometimes it's unsafe because of the conduct of the prosecution. For example, where you discover that something should have been revealed to the defence before the trial or during the trial that never was, and you've only discovered it afterwards. That would render a conviction, or could render a conviction, unsafe and require the court to quash it. Sentence appeals are quite different because if you win a conviction appeal, generally speaking, the Court of Appeal will order a retrial. Sentence appeals are self-contained. That they succeed where you can persuade the Court of Appeal that the sentence was either excessive or wrong in principle. And generally speaking, you're going to the Court of Appeal because your client has received a serious term of imprisonment that you can argue was too long. And so you're saying the sentence was excessive. If you succeed, and very often you do on sentence appeals, I think more sentence appeals are allowed than conviction appeals. And if you succeed, that's it. The court reduces the sentence, sometimes allowing your client to be released on the day of the appeal. I've had several of those. And others where the sentence is reduced so the client gets to go home early. Sometimes conviction, the sentence is quashed altogether and a non-custodial sentence is imposed in place of custody. But the advantage of a sentence appeal is that there's no going back for a further trial. Once it's done, it's done. Your client knows where he is and the matter is at an end. I've been appearing in the Court of Appeal since the early 1970s, and I suppose over the years I must have carried out hundreds of appeals in the Court of Appeal, many of which have been very successful.